I'm here with Jason Neufeld from South Florida. Jason, thanks for joining us today. You are a elder law attorney. You do Medicaid planning and related work. I was hoping you could start out here by telling us a little bit more about who you are and what you do and exactly what elder law consists of.
Sure. Nick, first, thank you very much for having me. It's a pleasure to be here speaking with you. Again, I'm Jason Neufeld. I'm the founding partner of Elder Needs Law. We have our two main offices are in South Florida, one being in Aventura, the second one being in Plantation, which is the one's Dade County, the other one's Broward County. But we service clients throughout Florida. After this phone call, I've got a consultation with a gentleman in Jacksonville and another one in Hillsborough County just later on today. So we really service all of Florida. And elder law, I think it's a really interesting question. People go, what is an elder law attorney? Because it's not just one thing. Elder law is really an umbrella term for lots of different things. So there's some areas of elder law that most people are very familiar with. There's things like probate and estate planning, right? Your wills and your trusts and what happens to your stuff after you pass away. And, who's going to make decisions for you if you become incapacitated, guardianships. And then there's some areas of elder law that are less well understood. And primarily those tend to refer to special needs planning and Medicaid planning. So as an elder law attorney, I focus my practice primarily on Medicaid planning and estate planning, and then I have attorneys who work for me that will assist me with my probate and guardianship matters.
And I just want to touch on sort of how what you do fits in with what we're doing at Elder Guide. And the obvious fact here is that nursing home care is getting increasingly expensive, as is assisted living care. A significant percentage of people at some point, if they live long enough, will end up in one of these facilities, and at $8,000 to $10,000 a month, the average American family is going to run out of resources. And at that point, common myth is that Medicare covers this. It generally doesn't, aside from short-term rehab, and a significant percentage, some say up to 60 or 70% of people in nursing homes end up relying on Medicaid to foot the bill for that care. And so I was wondering if you could just, sort of touch on what Medicaid is, how it works in Florida. I know it's a little bit different in Florida. We've got 3 programs instead of just one, like many states have, and sort of the nuances of those programs and who each would be a good fit for.
Yeah, I think you hit the nail real nicely on the head in terms of the theory behind Medicaid planning is it answers the question, most of us are going to need long-term care, whether it's first needing help in the home, and then sort of graduating to moving into an assisted living facility, and then from there typically being in a nursing home. And the big question is, how are we going to afford these things?
Right.
And Medicaid is one of several possible answers to that question, right? So there are people who have, many hundreds of thousands of dollars or millions of dollars, and those people are usually able to self-pay, and that's great, and that's wonderful. There are some people who have long-term care insurance, and that's wonderful too. That's just as good as cash. Those policies are incredibly expensive.
Right.
The biggest misconception is that Medicare is going to cover these expenses. People go, I worked my whole life, and I've got the best Medicare supplement money can buy, so I'm all good. And I sometimes have to be the bearer of bad news. Let's say, well, in fact, Medicare has a very limited home health care and has no assisted living facility benefit, and it has also a very limited nursing home benefit. Basically, in a nursing home scenario, Medicare will cover the first 20 days for free, and then there will be a copay from days 21 through 100, and after 100 days, you're on your own. Medicare does not cover any of it. Doesn't matter if you have the Cadillac of Medicare supplements. So how are we going to pay for these things? So you mentioned that nursing homes can cost between $8,000 and $10,000. I think you're getting that statistic because I think that's a nationwide statistic. In Florida, where I practice, the average cost of a nursing home in the state of Florida is a little over $9,500 per month. And in South Florida, where I'm based out of, it's really more like $10,000, $11,000, $12,000 per month. So that's an extraordinary expense. And there are people who they're retired and they save their entire lives and they go, I've got a couple $100,000 in the bank. And the reality is, if they're not planning in advance, they're going to be wiped out. Long-term care is by and large the largest threat to people's assets that they've accumulated over their life.
Absolutely. And so what are the three separate programs in Florida, and sort of what are the distinctions between them? Because I think a lot of people get this confused.
Yeah, absolutely. And so that's another real great question, because Medicaid is another umbrella term for lots of different programs. I think there's maybe 14 or 15 different flavors of Medicaid in Florida. There's Medicaid for the impoverished and disabled who are just looking for health insurance. There's Medicaid for pregnant women and their young children. When we're talking about Medicaid in a long-term care context, there's really three separate programs that we are primarily dealing with. So on the highest level of care, we have what's called the institutional care program. We often refer to as ICP for short. And that's only for people who are in a skilled nursing facility, long-term care, skilled nursing rehab setting. And that facility, the deal with Medicaid is the facility will take essentially all of your income. There's some exceptions to that, which I think we'll get into later on in this interview. But essentially, you're looking at giving the facility all of your income, retaining about $130, and then Medicaid will pay the difference if you are otherwise qualified. So, if someone who's on Social Security making, $1,500 or $2,200 a month, and these facilities are costing $9,000, $10,000, $11,000, $12,000 per month, that's a really nice deal to get Medicaid to cover that difference. And if you are not in a nursing home setting, if you need a lower level of care, which is either assisted living facility care or home health care, right? Paying for someone to come in and help take care of people and assist them with their activities of daily living, that's a different program. That's referred to as home and community-based services Medicaid. It's also sometimes referred to as the Medicaid waiver program. It's also sometimes referred to as state-managed Medicaid long-term care program. So these are all different terms that refer to the same thing for people who are not in nursing homes but are in ALFs or at home. The difference between the two programs is if you're in the ICP nursing home program, there's no wait list. Once you're qualified and submit an application, you're sort of in the program for all intents and purposes. For the waiver program, where you're in an ALF or at home, you are on a wait list. And the wait list is not first come, first served. It's based on a priority score depending on your needs. So part of our service, if we're hired to assist folks, is we coach them through that placement process. Now, I don't have a magic wand. I can't make everyone jump to the top of the list, but we know what questions they're going to ask. And what I tell people is, we're not lying, we're not making anything up, but there's multiple ways to tell the truth, and we're going to tell the truth in a way that's most advantageous and get them a higher priority score than they otherwise might. And once they are approved for that program, they are going to receive typically about $1,400 that will go towards the medical portion of an ALF bill. So when you're in an ALF, there's the room and board that Medicaid does not cover. Then there's the medical part that Medicaid does cover. And then if you're at home, we're seeing them typically approve between 15 and 40 hours per week of home health care. And sometimes I have some clients who get more, but typically when you want more than 40 hours per week, you're kind of fighting them on it a little bit. There's more advocacy involved. And in addition, with all these programs, Medicaid is going to be paying for your Medicare Part B premium. So that's automatically deducted from your Social Security retirement check. So you're going to see a little bit of extra money come into your account every month. They're going to pay for your copays, your prescriptions, and all these things. And there's the one other program that I'm seeing increase in popularity, or people are more interested in, is it's a lower level called QMB, which stands for Qualified Medicare Beneficiary. And so I'll give you an example. I was invited to speak at the Leukemia and Lymphoma Society's annual conference in Broward County. And by and large, these people were under the age of 65, but they have these blood cancers. And what their biggest concern was that the doctor's bills are incredibly high, and more so than that, the prescriptions are astronomical, the medications and the treatment that you need for these things. So QMB, which is for anyone who is deemed disabled or over the age of 65. Once you're over the age of 65, you don't have to meet the disability requirement anymore. So when you're deemed disabled, then the qualified Medicare beneficiary program is going to pay for Medicare Part B Medicare Part B premiums, doctor copays, and cover these prescriptions. Because even if you're under the age of 65, once you've been disabled because you have this cancer diagnosis, after 2 years, you get Medicare. Right? So now you're going to get Medicare, and now you can qualify for this QMB program that's going to cover these copays and these prescriptions. So ICP nursing home, Medicaid waiver for ALF or home care, or QMB, which is sometimes people on the waiver program, because there's a wait list, are also simultaneously applying for the QMB program because there's also no wait list for the QMB program. So I know I just threw a lot out at you, but those are the three main programs that we are primarily working with.
And it's great information. Thank you. So just sort of getting a big picture overview here, my understanding is, to qualify for Medicaid, just generally speaking, for long-term care coverage, you need to satisfy two tests. You have an income test, you have an asset test. The numbers change a little bit every year, state to state. The income test, I believe it's $2,349 a month of income you can have in 2020, and the asset test in Florida, at least, is $2,000. Now, that's for a single individual. How does it change? How does it change if I'm applying to get into a nursing home, or if I'm in a nursing home already and I'm married, and I have a spouse living at home? How does that affect that calculation? And what can my spouse retain?
Yep. Certainly. So Florida and the United States government have enacted these I refer to them as anti-spousal impoverishment laws. And the idea is, if one spouse is in need of care and the other spouse is mostly healthy, it is not right to force the well spouse, which we've referred to as the community spouse because they live in the community and are able to be independent in the community, that we shouldn't force that community spouse into poverty to help pay for the sick spouse's care. So there are sort of two general concepts that can help out in this situation. One of them is referred to as the Community Spousal Resource Allowance, or CSRA. And that says in Florida, and that will vary between states. So that's why when we're talking about elder law and Medicaid planning, very state specific. Someone who's watching this in another state has got to talk to an elder law attorney in that state. I'm only familiar with Florida law. So in Florida, the Community Spousal Resource Allowance is a little over $128,000. It's actually $128,640. So what that means is the sick spouse who needs care can only have $2,000 to their name. The well spouse, though, is allowed to retain up to the Community Spousal Resource Allowance. And then if they're under $128,640 plus the $2,000 that my Medicaid planning client is allowed to have, then they will satisfy that asset requirement. So if they have more than essentially $130,000 plus $1,000, then we have more planning to do because they won't naturally qualify for the benefit.
So the next question that invariably comes up is you can't qualify for the income test if you make over $2,349 a month in 2020 at least. But of course, as we just mentioned, nursing home care can cost anywhere from $9,500 to $12,000 a month. So if I make $3,000 or $4,000 a month, I still can't afford the nursing home of my choice. So, what do you do in that situation? I mean, does that mean, do you automatically just not qualify, or what are the options?
Yeah, thankfully we have planning options because Congress and the legislature also recognize that, there are people who don't have two pennies to rub together because of their expenses that are related to the way they live their life, but they have income that's too high, and their gross income, because they've worked hard, so they have Social Security income, and they might have a pension or a qualified retirement account that comes along with that. And if those two numbers, or any source of income, really rental income, earned income, if they get any dividends, any source of income, if you combine all those sources of income together, and that number is more than $2,349 gross, before anything's deducted, you are not qualified for Medicaid unless you utilize one of two devices. The first one's referred to as a qualified income trust, or QIT. Sometimes that's referred to as a Miller trust. So QIT, qualified income trust, Miller trust, all the different terms that refer to the same exact thing. And the idea is that if you go to a elder law attorney and they create this income trust for you, and then we walk you through the process, you literally, once it's properly signed and executed, we instruct you how to take this trust, you walk it into your bank and you say, I want to open up a qualified income trust account. And nearly every bank will know what you're referring to. And then all you have to do, or the trustee has to do, is every single month, for as long as you want to be eligible for Medicaid, you're going to take any gross amount of money over $2,349, or whatever the income cap is that year, because it changes every year. Right. So you take it over the income cap amount and you make sure you deposit it into the qualified income trust, and then boom, like magic, you satisfy the income requirement. So a lot of people are concerned because they think of these trusts and they go, I think people think of trust as something that accumulates money. And they go, well, I don't want to lose that extra income. And luckily I'm able to tell them, you don't lose a dollar of it. The money goes in and the money comes right back out to go pay for whatever it is that you need that's related to health or medical related expenses. So if you're in an assisted living facility or a nursing home, it's very easy to take your extra income and direct it towards health or related expenses, as you have the nursing home expense or the assisted living facility expense. But there's a complication that arises for people who earn too much income and want to stay at home. If they're getting, for example, Medicaid is covering their home health care needs, well, they may not end their prescriptions and their co-pays and all these other health and medical related expenses. They may not have much more by way of non-medical or health related expenses. And the QI distributions from a qualified income trust are limited to those things. So if someone's living at home, instead of opening up a Miller trust or QIT, we are instead directing them to open up what's called a pooled special needs trust. These are professionally managed by nonprofit organizations around the state of Florida. There's probably 40 of them. I work with 3 of them that have been around for a long time, and I have a lot of experience with them. I know do right by the client. And what's nice about these trusts is they can be used to hold extra assets or extra income. So if you have an income problem because you earn too much gross income, you can place the difference in the pooled special needs trust every month, the way you would with the qualified income trust. Or if you have too much by way of assets, you can deposit extra assets in there to help you get you below that $2,000 level. The drawback with both of these trusts, well, the pooled special needs trust, you're paying a professional to monitor it. It's a very reasonable fee. People get nervous about that. Like the least expensive one that I work with, it has a $500 like one-time buy-in, and then they're charging 1.95% of whatever it is that they're managing per year. So, I tell people, listen, if you had money with your Morgan Stanley or UBS, you'd be paying 1.25. You're going to be paying a little bit more for this trustee service, which is, I think, not a bad deal. The bigger drawback with both the QIT and the pooled special needs trust comes after the Medicaid recipient eventually passes away. And if there's money left in the account when they pass away, in either scenario, the trustee is obligated to notify Medicaid. Medicaid will then send a bill, and then anything left in that trust has to go back to the state of Florida before it goes to any heirs. So in a QIT, that's not a big concern because money should be going in and coming right back out. And in fact, it's an account that should be zeroing out every month, right? Money goes in and then you bring it right back out to pay for your ALF bill, your nursing home bill. If you have, some people are putting significant amounts of money in the pool trust, and we want to balance that with other Medicaid planning strategies that don't have that Medicaid payback requirement, because while it's nice to remain liquid, you can use this money for anything. By the way, in a pooled special needs trust, use the money for health-related expenses or non-health-related expenses, needs or wants. And my favorite example is that a client who was living at home, and we'd done a bunch of different Medicaid planning strategies. We got her some home health care through the waiver program. And part of it was she had money that was in a pooled special needs trust. And she called me up and she goes, Jason, you said needs or wants, right? I go, yeah, really, almost anything's available to you. And she goes, I love the Miami Heat, and I want to buy season tickets to go see the Miami Heat. And I said, this is before coronavirus, of course. I said, go have fun. I go, now you can only pay for, I'm assuming you're going to buy 2 tickets and you cannot use your money to pay for anyone else's expenses. So if you want to go in halvesies with your son or someone like that who's going to take you to the game and you pay for your half of the season tickets, God bless you. Enjoy it. It's your money. Have fun. Be entertained. And I loved it. And that's a perfectly valid expense.
We covered income, a little bit of assets there. You hear $2,000 in assets and it sounds like nothing. And I think that confuses quite a few people into thinking that there's no way they're ever going to be able to qualify because they're simply not impoverished enough. You touched a little bit on how you can do some asset planning, with some of these trust options. But I think the most interesting angle here from an asset perspective is, sort of looking at the specific assets and seeing how they're counted for Medicaid purposes. And it seems like most of the assets that are commonly owned by, the average American family are either not counted or they're counted a little bit differently. And so I just wanted to kind of go through a list there and touch on some of the big ones and just go through them. The first one, and probably the most prevalent, is going to be a home in personal residence. In Florida, we have something that is sort of unique, I think, to Florida and maybe one other state, which is known as homestead protection. I wanted you to touch on what's the difference between a personal residence that's my homestead and a vacation property or a non-homestead property. Why do we care, and how does it affect this Medicaid asset test?
Yeah, first, I think it's important to mention that when we tell people that you can only have $2,000 worth of assets, that only refers to countable assets. And luckily, not every asset is countable. So the homestead, real estate in general. If you are a single individual and you have a homestead, if the value of that, the equity of that homestead is less than $595,000, then you don't have to worry about it being counted as an asset. So what happens is most people who are coming to me, their homes for Medicaid planning, their homes are worth under that, and it's not an issue most of the time. But occasionally you have people who they have a house that's worth $700,000. And I have to tell those people a few things. Number one, I ask them, is there a mortgage? Because it's not the value of the house. That's why I corrected myself. It's not the value of the house that counts. It's the equity, right? So if you have a $700,000 house that has a $200,000 mortgage associated with it, then you have $500,000 worth of equity. You are under that equity limit and you are fine. If you have a $700,000 house and you have the mortgage is all paid off, well, now we're talking to our clients about things like taking out a small mortgage. And so they're going to enrich themselves by an extra $200,000, but they're going to draw down the equity, and we now have other ways of protecting that money. So there's some exceptions to that. That's for a single individual. If we have a married individual, as long as there's anybody who is dependent on living in that house, we have a spouse, we have kids, sometimes they're adult disabled children, then the house can be worth $1 billion and Medicaid can't count it against you. As long as there's someone else who's not receiving Medicaid, or there's someone else living in that house who's dependent on living there, then value is never going to be an issue. So those are the basic homestead rules. We have some people who have extra second homes, vacation homes, or rental properties and things like that. And the other way you can take a piece of real estate and make it turn it into a non-countable asset is if you rent it out. So people have vacation homes and they want to keep it in the family. I go, you got to rent it out to someone for something that's approaching fair market value. So what I mean by that is you can't rent it out to your son for $100 a month if the fair market value rent is $2,000 a month, right? So as long as we fair market value, once you rent it out, now that's more income coming in, right? So that might mean we have more money we put into a qualified income trust or a pooled special needs trust, but now this big, huge asset is protected. And we have other things that we can do to make sure that after our client passes away, even that property is not subject to Medicaid estate recovery.
One situation, and I don't know how frequently this happens, but just as you're talking, I'm envisioning the situation where it's, I don't have a spouse or anyone else living in the house. Maybe they predeceased me. I move into an assisted living facility. I lived there for a few years, and the next thing you know, I'm in a nursing home, and I'm applying for Medicaid, but I haven't lived in my house for a while.
Right.
Is how does that work? I mean, is that still treated the same way?
Yeah, so those people have to make a choice. So yeah, if you are not living in the house, Medicaid takes the position that if you have what's called an intent to return home, then they will still not count that asset against you, even if it's unlikely, right? Even if you're in a nursing home and there's no way you're ever leaving that nursing facility because you need 24/7 care. As long as you have the intent to return home, and what I tell people is, if you were to walk into a nursing home and ask everybody in that nursing home, would you like to go home? Would you like to go home? Would you like to go home? They would all say yes, even if it's never going to happen. So Medicaid will assume that they have the intent to return home unless they're renting it out, right? Or unless they are,
Right.
they've done something else to show they've done something else to show that they don't intend to return home. It won't be an issue. Some people, though, they're in a nursing home, especially in a nursing home setting, right? Because all of your income goes to the facility. You don't get to keep income set aside for paying the taxes and the upkeep and the utilities and the cable bill and all these things that come along, all these expenses that come along with home ownership. So some people say, well, I'd prefer to sell my house if you don't have family who's willing to kind of take over those sorts of payments. So we deal with both scenarios. And the answer is yes, we can sell the house and use other Medicaid planning techniques to protect their access to these benefits. Or if they want to keep the house and not deal with it, then we can now save it as sometimes we convince family members, listen, you have an interest in paying these expenses because this is your inheritance, essentially. So pay the tax bill, pay the insurance, and you'll get the house after mom or dad passes away, and we can work that way too. So kind of whatever people want to do with their real estate, we're able to assist.
Oh, that's a no-brainer. And the last thing here on real estate, before we move on to another asset type, is you hear a lot about what's called a Ladybird deed.
Mm-hmm.
What are they, and sort of how do they fit into all this?
Yeah, so Ladybird deeds are a really common estate planning technique that we use. And it's really not a Medicaid planning technique when it's dealing with your homestead. It's more just good, solid estate planning. So if the house is just in Mr. Smith's name and Mr. Smith passes away, his heirs have to find his will. They got to go to the probate court, and they got to go through that whole process before getting the judge to order title to go to whoever it's supposed to go to. A Ladybird deed can circumvent all that. And essentially what a Ladybird deed says is, I, Mr. Smith, deed this property to myself to do with whatever I want for the rest of my life. And if I don't sell it or do anything else with it, and I pass away, then the deed says who gets the property. And it's like magic, right? After they pass away, you record the death certificate, and it's immediately now owned by whoever's listed in that deed. The reason why it's important to structure the deed that way, as opposed to there's regular life estates, and there's just sometimes people go, let's just put the house in the name of my son or daughter or both of them and let them be joint owners. And the reason why we don't want to do joint ownership, we want to do the Ladybird deed, is because the big no-no with Medicaid is there's no gifting allowed. You can't take assets and give it to someone who's not your spouse. You can actually give to your spouse. You can't give anything away to the kids. And the Ladybird deed avoids that problem because they're in fact not giving anything to anybody as long as they're alive, because they retain the right to take it back or to change the beneficiary designations. And so only after they pass away, what does the interest in fact change to, and we avoid the gifting penalty, and we also avoid probate. So for a homestead's not going to be counted. It's not going to go through, homestead's creditor protected. Medicaid is not any better or worse placement than FPL or Visa in terms of how creditors are able to attach themselves to assets. So if it's your homestead, the Ladybird deed is not a Medicaid planning tool, it's just good estate planning. But for income producing property, the Ladybird deed is great because as long as we can get the asset to avoid probate, Medicaid won't be able to touch it in Florida. And that's also a very Florida unique rule that is not always the case in many other states.
I want to talk about, let's move on to retirement accounts. So we have 401ks, IRAs, other types of retirement accounts. Hopefully we all have these at this point.
Right.
My understanding is that generally speaking, these do get somewhat favorable treatment under the Medicaid asset counting rules. But these are also sort of unique assets because it's sort of, we think of it as a stock account, but it also spins off income because we have these required minimum distributions we need to take after we reach a certain age. And I was hoping you could talk a little bit about how these assets are treated, what happens if I don't take the RMD, and sort of what are the nuances of this area.
Yeah, absolutely. Because oftentimes it's the largest asset other than the house. It's, they've accumulated money over the course of their working life. And oftentimes the 401k or the IRA will exceed the value of what's in their checking, banking account, or brokerage account. And the rule is, generally speaking, they are counted as an asset unless they are paying out in regular distributions. And this is only, by the way, the case for qualified retirement accounts. There are lots of non-qualified annuities that are paying out regularly. There are people who have just a standard investment brokerage account that might be spitting out income regularly. That these special rules only apply to qualified retirement accounts like IRAs, 401ks, Roth, SEPs, and these things that fall under qualified retirement, the code of the Internal Revenue Code. So as long as it's a qualified retirement account and it is paying out in regular, usually it's required minimum distributions, the law just says regular distributions, then the value of that asset is not counted. So you can have, $500,000 sitting in an IRA account, and as long as it's paying out and required minimum distributions, $500,000 is invisible as far as Medicaid's concerned. Now the income counts again, right? So that might be more money that goes into the income trust or the pooled special needs trust, but the asset's protected.
You touched a little bit on annuities there. That brings me, to this idea. We also have annuities, life insurance. There's a million products that sort of fit into these categories. The way I see it, they all sort of, you can break them all out into two basic groups. It seems, you have those with cash value and those without. And the classic example of one of these financial products without any cash value is like a term life insurance policy, which many people have. Those I know are not a countable asset because they really don't have any value until you die. But what's the difference between those types of life insurance products and ones with cash value, such as whole life insurance?
Yeah. So I tell people to think about it this way. So unless it's subject to an exception, like it being a qualified retirement account or your homestead, something like that, if you can touch the money while you're alive, Medicaid will count it against you. So you can have $1 million life insurance policy, but it's a term policy and there's no cash value, so there's nothing to access. That $1 million is not counted as an asset according to Medicaid, so you're fine. But there are these lots of other insurance products like universal life insurance or whole life insurance or these hybrid policies where they accrue cash value over time. And if you can touch the cash, then the money might as well be sitting in your bank account. So we have lots of these folks, and we're doing a analysis depending on we're going to compare the cash value of the policy to the death benefit. So I have people there are lots of these $10,000 essentially it's for burial expenses, and they're $10,000 death benefit policies. And some of them have cash value components to them, and they might have $9,000 worth of cash value. Well, if that's the case, I'm telling my client, cash it out. We're going to lose $1,000 and we're going to have to deal with it, but it's not worth monitoring and kind of keeping on the books. Let's just cash it out, and then we'll protect the cash value another way. If on the other hand, it's a $100,000 death benefit and there's $50,000 worth of cash value, well, it'd be a shame to lose that $100,000 death benefit. And so what we're instructing our clients to do typically is we are getting them to borrow against the cash value. So most companies will let you go down to about $500. And so you can, then everything else, you kind of withdraw the money and we protect it another way. And now we have to treat the $500 like it's money in the bank. So if you have $500 in cash value with your life insurance policy, that means you can only have $1,500 sitting in your bank account, because everything together cannot add up to more than $2,000.
Just sort of wrapping up the asset analysis here, a couple of follow-up questions. One, and you touched on this already, you talked about people, giving assets away in the context of, a gift of your home to your kids. But that is, bigger picture, that is something you hear about all the time. People saying, "Oh, I'm just gonna give everything away to my kids. I'm gonna sign these things over," and that, they think that that's somehow going to accelerate their qualification for Medicaid. You also hear about, hear stories of people getting into trouble for doing that, and then falsifying their Medicaid applications. I mean, this is really serious stuff, and it's fairly complicated. Sort of, what are your thoughts on gifting in general, and sort of what are the mistakes you're seeing people make?
Yeah. So a few things. The first is, I tell people to keep in mind, and when people work with me, I make them fill out a one-page asset worksheet. They're listing everything. And one of the questions is, have you given anything away in the last 5 years? And I do that because, and after they do that, I also remind them that not only are Medicaid's not taking our word for it in terms of when we present to them bank statements and things like that. You are also simultaneously signing a financial information release. You're giving DCF, which is Department of Children and Families, which is the agency that runs Medicaid in Florida. You're giving DCF the ability to conduct their own independent investigation into your finances. They can contact the IRS, they can contact your banks directly, and you've given them permission to access all of your information. It's a requirement. You can't apply if you're not willing to give them that permission. So I tell people, you better not hide anything. If you gave something away, they're going to find out about it. And if there's an account, I actually have a real life example where I had a client who was a US citizen, but they were originally from Argentina. And they didn't think that Medicaid would ever find out about a bank account they had in Argentina. So they didn't disclose it to me. I have it on my worksheet. I go, look, right here, you didn't tell me about it. And I told you they're going to find out about these things. Well, I didn't think they'd go abroad. I go, well, I'm sorry. Now you've been denied, and now we have more work to do, and that's fine. So, but generally speaking, and so people get back to your main question, which was about gifting. People do kind of have two different, I think, general thoughts. They go, I have $200,000 in the bank. I know I can only have two. I'm going to give 198 away because I want my kids to have this money anyway. So that is, of course, going to get them in trouble, because if you do it within 5 years of applying for Medicaid, because you're not allowed to do that, and Medicaid takes any gift and they assume you do it for the purposes of qualifying for Medicaid. And you have the burden of proving it was for some other reason, which is a very hard burden.
Right.
The other way people get in trouble, I think a little bit more innocently, is they go, well, the IRS says I can give $15,000 a year to anyone I want without having to file a gift tax return. And that's in fact true, but just because the IRS says something's okay doesn't mean that it's okay with Medicaid. They're two different agencies. They don't always play nicely with each other. So sometimes it's just, and they, people are, they're giving the regular gifts away to the church and to the grandkids. And depending on the value, sometimes we can get around it. But, we're talking about $15,000 or real large sums of money. It's something that we have to take back. What happens is, if they find out that well, first of all, if you lie to them, that's a felony. No one wants any part of that. So that's the first thing. The second thing is what happens is you might be approved for Medicaid, but then they impose what's called a penalty period. So the penalty period doesn't have to last forever. So what they do is they take the amount of gifts over the past 5 years and they add it all together. And and they take that number and they divide it by the average cost of a nursing home in the state of Florida, which is how I know, by the way, that it happens to be a little over $9,500. This is a number I'm looking at, right? So when they do that, so that number will give you the number of months in which they'll say you're approved, but you were delaying your benefits for this number of months. So if you, just to use easy math, if you've given away $19,000, they're going to go, am I doing my math right? Yeah, $19,000. then they're going to go, well, you cannot get these benefits for 2 months. Sometimes that's okay with my clients, right? They say, I gave money away to my kid. I want to help them buy a house, and I will accept the fact that Medicaid will not give me these benefits for 1, 2, 3, 4, 5 months, whatever it is. But when you start giving away serious amounts of money, that's a big deal. So, and there's no cap. I mean, just because if someone gives away $500,000 or $1 million, there's no limit as to how many months they can delay that benefit for. So we want to be real careful and avoid gifts whenever possible.
As you're saying this, I'm thinking to myself, what happens if I have this money coming in, and I'm not even necessarily gifting it away. I'm spending it on, if I go to the store or this or that. And they're operating under the assumption that that money I can't account for has been gifted. It seems like record keeping must be critical, regardless of whether you're talking about gifts or other payments.
So so it's very good. So what happens is when Medicaid looks at your financial records and they see, typically if it's $100 or something like that, that's not going to raise a red flag. Although I tell people it might. I tell people that it's these large chunks of money that are going to raise the red flags, and you may be called upon to explain what this expense was for. I also tell people, by the way, that's the kind of the first tool in Medicaid planning that you don't really need a lawyer for, is you are allowed to spend money on yourself for anything that you need or want. You want to upgrade your house, go upgrade your house. I typically tell people, let's think of things that are practical, like prepaying for funeral and burial expenses. No one likes to think about it, but it's something that someone's going to have to pay. Some point in time, if you have credit card debt, go pay off your credit card debt. If you get a mortgage, go pay off your mortgage. These things are not gifts because you are spending it on yourself. And again, needs or wants, there's really no limit to it. Other than you can only have one card. There's a few limits to it. So in any case, but as long as you're spending the money on yourself, it's not going to trigger the gift penalty. But when they see the money leaving your account, if it's going to your credit card, they may ask to see the credit card statement. As long as it's all your stuff, you're going to be fine. But if it's going to somebody else, it's going to cause a big red flag, and you're going to be called upon. As your lawyer, I'm going to be called upon to defend it, and we have to paper it. We got to find a receipt, and we got to find the invoice and say, what was this $10,000 transfer of money for, if it's not obvious.
And so, as a tangential issue that that I'm thinking about here also is, we're talking about the planning that I need to do if I want to be able to get nursing home care paid for by Medicaid, and we're talking about the assets that my spouse, assuming my spouse is living in the community, that she can retain, and what happens if my spouse in the community passes away first, leaving me in the nursing home? If I haven't taken any additional steps, it seems like those assets are going to come back to me, and it seems like that might disqualify me from receiving the Medicaid benefits I'm now dependent on. What type of planning is required there?
You are right on the money. So this is the intersection of Medicaid planning and estate planning, because you're absolutely right. When we have the community spouse, and I think everyone, they expect that the sicker spouse in need of care is going to die first, but it doesn't always work out that way. In fact, there's a large study done, I forgot when, I'm going to send you a link to it, but it basically says something like 10 to 20% of the healthier spouses who are serving as the caregivers will predecease the one that they're caring for, because it's a lot of stress. Really right. Becomes at what before the couple was operating as a team, and now the entire responsibility of living your life and maintaining your house, and now you're maintaining someone else's life as well, rests on the shoulders of just one person, and sometimes that's too much to bear. So now what we're doing in that case is we're doing some estate planning for both the sick spouse and the well spouse, and what we're able to do is, if we build into the will of the sicker spouse a special needs trust, typically we want to avoid probate, right? That's what estate planning attorneys are always saying. And 99% of the time that's true. There is this one scenario where we invite a probate, because in order to get this special type of special needs trust, which by the way, I just want to say is different. There's lots of flavors of special needs trust. It's different than the pool trust I talked about before, different than the income trust I talked about before. This is called a testamentary special needs trust. And a testamentary special needs trust can only be created through the will, and can only be created through a judge's order. So we are now in this one case inviting a probate to get the judge to say, okay, we want the assets instead of just staying in the sick spouse's estate, we want it going into a special needs trust. I'm sorry. Instead of going into the well spouse's estate and just being transferred automatically to the sick spouse whose benefits we're trying to protect, we instead want the well spouse's money and estate to go into a special needs trust for the benefit of the sick spouse. And then by doing that, all the money that's in the sick spouse's special needs trust is now not counted. Not only is it not counted for Medicaid eligibility purposes, but Medicaid has no right to it after the sick spouse passes away. So now these extra assets can pass to heirs without having to worry about Medicaid estate recovery. That's one tool. We have lots of other estate plan tools that we're doing to kind of take all these contingencies into consideration.
I think the big takeaway there is, this is a comprehensive type of planning here. You can't just be thinking about one individual. You need to be thinking about both spouses, and it sounds like several different scenarios and possible outcomes as well.
Correct.
And so, so that's the situation where the community spouse passes away first. Obviously, the more common situation is still going to be unfortunately, the person in the nursing home passing away first. We talked a little bit about state recovery. My general understanding of that is basically that certain assets, if you receive Medicaid and they paid for your long-term care and you pass away, certain assets Medicaid is going to go after you pass away, and they want to recoup those. Other assets they don't, and so you hear this concept of estate recovery planning, and how is that different than Medicaid planning generally? But then also, I'd like you to explain how they fit together and why you really shouldn't ignore one.
Yeah, it's all part of the same process, really. We try to take a holistic approach when we are consulting with our clients, and we're saying, listen, we can't always eliminate Medicaid estate recovery. Oftentimes we can. We can't always eliminate it 100%, but we are able to reduce it by typically by 80 to 90%. We can remove what Medicaid will ever be able to touch if we are planning properly. So for example, there's some tools, like I keep mentioning this pooled special needs trust. There are some Medicaid planning attorneys who rely on that as their sole strategy. It works. You can take any amount of money and put it into a pooled special needs trust, and now it's not counted as a gift, and it's not counted for eligibility purposes. But because it has that estate recovery problem, I call that lazy Medicaid planning, because you're now putting all these assets there, and Medicaid's gonna be able to go after all of it after the recipient passes away. So it has its place, and we use it very frequently, but we're never using it as a standalone option. It's not the only thing that we're doing, right? We want some money set aside so that the client can remain liquid and has all these advantages, right? The money can only be used for my client's benefit. That's wonderful. So it doesn't matter what happens to other people. But we have other tools where we can get money without it being considered a gift into other people's names. We have certain investments that we can make that may make them illiquid, but the investment is structured in such a way that Medicaid will never be able to touch it after my client passes away. So that's really what a Medicaid planning consultation is. As I'm telling people, we have lots of really neat options available, but none of them are the magic wand effect, right? They all have pros and cons, and that's what we're talking about during the consultation. But here are the options. That I haven't built this worksheet, so lets me think about what options in my mind make the most sense. I go, here's what we have to work with. And now let's come up with a combination of strategies that's going to provide my client with the most benefit while they're alive, and to make it more likely that their heirs will have something to inherit after my client passes away.
In all this planning, we seem to have this baseline assumption that I'm, able to come sit down with you, rationalize these choices and execute these documents. What happens if either I'm mentally incapacitated, or we start this process and somewhere along the way become mentally incapacitated? A critical part of any estate plan, obviously, is a durable power of attorney. how do they fit into all this though? And what are the drawbacks to sort of not keeping an eye on that and having a bad one?
I love this question because I tell people, of all the fancy planning and trust that I put together, this absolutely, without a doubt, the single most important document that I do is a well-drafted, enhanced, durable power of attorney, bar none. And the reason is, if my client becomes incapacitated and they have not planned with a good power of attorney in advance, then we are hamstrung. And now, instead of relying on a power of attorney, we now have to go through the guardianship process, which is a lot more time consuming and expensive. We have to be careful though with powers of attorney because they're not all created equally. I think some people have the sense that you can just download a document that's free, and there's lots of free powers of attorney on the internet, right? You can download free power of attorney, and it's funny. I did a separate video, which I'll send you later, basically looking at the 3 most common free forms that I see floating around the internet. And they have serious problems because there's a few reasons. Number one, there are a lot of old forms that are pre-2011 that are around the internet. And there are lots of attorneys who are still printing out these forms because they're not estate planning attorneys. They're just, I call them door law attorneys. Whatever walks in the door, they'll take. And there's using these old forms that don't comply with 2011 requirements. And I think people think that you could just sign a document that says, I, Mr. Smith, give my son and daughter, Joe and Susan, the ability to make all decisions for me, no matter what, so help me God, and that's it. And then they sign it and they think that's okay. Well, that's not how these documents work. These documents are very specific. And in fact, if what you're trying to do is not specifically listed in the document, then you can't do it. Your agent can't do it, right? So that's the big problem with these generic forms that we see floating around the internet. Not only that, there are certain provisions where you can be as crystal clear as you want, such as creating revocable and irrevocable trust, which is, we're doing a lot of that in Medicaid planning. And if they're not properly spelled out and initialed, not only signed, but and initialed right next to it, you also can't do it. So this is a problem I have with people who, I say, please don't cheap out on the power of attorney. Don't download the free form. There are forms, by the way, that I tell people you can download for free. You'll probably be fine with. The Florida Bar has a free Florida healthcare surrogate statute form, a healthcare surrogate designation form, so who can make healthcare decisions for you. That's going to be fine 99% of the time. I happen to like my form better because I make it a lot more detailed, but it's not strictly needed, and I just like things to be clear and put in a way that I think is going to make my client's life easier. But some of those free forms are fine. Don't mess around with the free form, though, when it comes to a durable power of attorney.
That really leads into the last question I want to ask you here, and and this is another common theme that you see out there of people, especially today with the internet. They think that they can research these things, and everybody wants to do it yourself. This stuff is complex. I'd say that's an understatement. This might be one of the most complex areas of estate planning, frankly. Not to mention the way it ties into other areas of estate planning and other issues that we've addressed here. So, what is your advice to people who think that they can do this themselves, and where are they more likely to end up?
First of all, I always like to say I'm very sympathetic to the fact that Medicaid planning can be expensive. And I tell people that there are some people who already qualify for Medicaid, right? They already have about $2,000 in their bank account. They make less than $2,349 from all sources combined. And I go, you can just call your local area agency on aging and they'll walk you through the process, and that's for free. And I get that, and I tell people that all the time. There's no law that requires you to hire an attorney to file your Medicaid application for you. Now, I will tell you this, especially in South Florida, when you call these agencies, you're on hold for, and I'm not making this up, between 45 minutes and an hour and a half. They have, I think in Miami, we have like 9 people who are covering the entire Miami-Dade County. It's something, I might be making that up, but it's some crazy low number. So not only that, but because these folks are so overworked and maybe even underpaid, they are sometimes erroneously denying applications that should be approved. Now, if you have $2 in your bank account and you earn $500 a month, I don't think that's going to be your issue.
Right.
But I warn people, though, if you have any kind of substantive assets and you are trying to do this planning yourself, you got to be prepared to answer questions. The government will ask a lot of questions. It's part of what you're hiring someone like me to do is to be your voice. I'm your mouthpiece. You don't interact with the government. I interact with the government for you. You don't present things to them. I present things to them in a way that I know how they want to see it. And so it's going to be more likely that we're not going to run into these problems. But even my applications, every once in a while, my applications are denied. And because I know I don't submit applications unless they should be approved, I then go through what's called a fair hearing process, where then I can escalate the issue to a district attorney, a Department of Children and Families attorney, and go, what's the problem? And most of the time they're going, there's no problem. There was a mistake done by our staff on the lower level, and then it's approved. So for people to to endeavor to go through that on their own, I say, listen, feel free to give it a shot. And if you run into a problem, then you can come back to me. I'm not going to turn you away, but I also understand that I get it, freeze free. And if that's what you feel like you need to do, then I understand that as well.
That makes a lot of sense. This was great, Jason. Thank you. Thank you so much for taking the time to speak with me today. I found it to be incredibly informative, and I'm sure that our people visiting our site are going to as well.
Nick, it was a pleasure. I hope you can tell I love talking about this stuff. I love educating.
I can tell.
I try to put a lot of good information out there, and there's a lot of misconceptions when it comes to Medicaid planning. A lot of rumors and gossip and old wives' tales. And some people think you can't do it if you don't have 5 years to plan. Some people think they're going to take your house, and all that stuff is 100%. There's a lot of stuff that's not true, and so I enjoy trying to dispel these myths and give people some guidance.
Thanks again, Jason. Really appreciate it.